Again, if you know you're under investigation, don't talk about it with anyone. When I say anyone, I mean anyone. You can talk about it to an attorney that has an attorney-client relationship with you, but don't text about it, don't post about it, don't do videos about it, don't talk to anyone about it, because law enforcement, CID, NCIS, OSI, they're going to be monitoring your social media. They're going to be looking at what you post on TikTok. They're going to be looking at what you post on YouTube. They're going to be interviewing your friends. So if you say something that potentially could be incriminating or could be, used against you in a way you didn't even think was incriminating, it's going to be a problem. So go radio silence on this. That's why it's always good to have a good attorney you can talk to, because not only are we going to be able to walk you through the process, but we're a confidant. So when everything looks dark, you can reach out and say, what the hell is going on with my case? And we can at least inform you the best we can and make sure you don't make any mistakes early on. The second thing is, depending on the case, you may be able to actively have an attorney or investigate the case simultaneously while NCIS, OSI, or CID is investigating the case. Now, that isn't always possible in every single case, but let's say you have a he said, she said sexual assault case that the issue is going to turn on alcohol and how intoxicated you were, how intoxicated the alleged victim was, and there are witnesses that were there that night who can speak to this. Oftentimes, CID, NCIS, or OSI, they may interview these individuals and have confirmation bias and try to get them to say certain things or to make you look more drunk or to make her look more drunk, whatever is going to feed their narrative. And oftentimes you don't want to have to rely on their reports literally a year and a half down the road, because if you do no early investigation, let's say it's a case that's going to take you a year or a year and a half to go to trial. Now your lawyer gets this, we're reading the police reports or the ROI, the report of investigation, and we have a report from a year and a half ago. And that witness probably doesn't remember what the hell was going on a year and a half ago. So you're stuck with what they told CID, NCIS, or OSI. So one approach can be to just go ahead and interview them, either have a lawyer or have a lawyer's investigator reach out to them and interview all of these witnesses, memorialize that in writing, get sworn statements, get affidavits, get declarations, so we can get all of this locked in early while this information is still fresh in the witnesses' minds. In other cases we've had, we're able to get surveillance video. There's surveillance video which is available that's critically important, and we can file requests for preservation of evidence and so on. So there are cases where we can be more proactive in the investigation. That way, if you are charged, we have what we need and we're ready to attack. So otherwise, the government's going to be spending the next year to a year and a half, likely, investigating you to try to prove you did something wrong or did something criminally wrong. And nothing's been done on your side to show that you didn't do this. So at least if you have an attorney or those attorneys have investigators or whatever you're going to use, you can try to get ahead of it as much as possible. That way, if you are charged, we're not behind the power curve. And so the other way that can be utilized is if at the time there's a charging decision. Now, a charging decision, who's going to make that decision really depends on the nature of the charges. And that's a video for another day, but it may be a command decision, it may be a JAG decision, it may be what's called an OSTIC, which is the Office of the Special Trial Counsel. But whoever the decision maker is ultimately going to decide whether to charge you or not. There's going to be a lot of hands in the pot that are going to help make this decision. So if we've done an investigation or your lawyer's done an investigation and you've got exculpatory evidence, and by exculpatory evidence, that's just a fancy word for evidence of your innocence or evidence that shows that you are not guilty of this crime they're accusing you of, we may be able to make a strategic decision to turn that over early to a prosecutor and hopefully keep you from getting charged. Now, in doing that, there's an upside and a downside to that, because if we know you're going to be charged, we may not want to turn over that evidence early and give them access to it. There's going to be a time when we're likely required to under the rules of discovery, but it may be a way to keep you from getting charged. And as I tell clients that at least call us, and I'm confident the ADC, DSO, or TDS attorneys are going to say the same thing, if we're able to keep you from getting charged, that's a win, because every day you're not charged by the U.S. military with a criminal crime or a crime is a good day. And so it saves you a lot of headache and expense and the risk of going to trial. So that's always a strategy that we can employ. And frankly, we've been very successful at that, having charges get killed or not be able to go to trial.